Yeah, the bag of beans cause redness, a red mark. It's got to find me.
Ouch.
Yeah. Got a dried bag of red beans and throw it.
Those the big ones?
They can be small or big, depends. Small ones taste better if you make red beans and rice.
Yes, but which one hits harder?
It just says red beans. I need an investigator. I think this is the turning point of this whole case.
Did we get that weighed tested?
Sean Fisher might be a little bit crazy. Aren't they all? It's just quite how much.
In the cabinet at the bottom.
I don't see
I
it,
believe.
yeah.
Oh, do you have something?
No, I got it. Okay, just getting the numbers.
Oh, okay.
Okay. All right, thank you.
Rolando Gomez. Rolando Gomez. Yeah, the other one. The other day. Yeah, it's the same.
Holding a little bit of volume.
Oh, there you go. It's like, it's a really good system. I don't know what you can. But that was kind of what they were like, oh, look, it's the background.
Oh. Oh, sorry.
I'm just thinking something that. Sometimes you're showing up on your seven.
Oh, okay.
That's it.
Wanna wait?
I don't have to, I'm good.
No, I'm saying, oh, this is before you go there.
Yeah,
Got it.
yeah.
Oh,
Thank you.
all right.
Yes. I'll forward it to
It's.
Barbara. Yes.
You can just your phone, but my name is on the one. I am the fun guy.
You're on the bond thing.
Oh, it's just play paperwork. There you go.
It's
Remember, I gotta run these restroom. I'll be right back.
gonna be a while.
Okay. not a problem.
Not a while, but until.
Yeah, I'm coming.
Sorry.
No, you're fine. If I missed something, my apologies. What's up?
Okay, okay.
But can you send me emails? It's not-
11355. Yeah, I'm gonna do 11355.
Oh, is that a five?
Yeah.
I thought that was a nine.
My apologies. No. I don't have the left hand right. Thank you. Well, technically, I am Dr. Jurisprudence, but no one cares about that. So. Yeah. Let me know.
Case I thought was recalled from last week, but I don't see any doctor. Where is it? No, Gatorade is, yeah.
Okay.
Warrington, I thought was recalled. I don't see him on the docket. SID number is 1134367. My notes. Okay, I just had a note on this. Is it on Thursday?
Yeah, I think they're right.
I'm gonna check, that's fine. If that's- I know Monday one more, I took the day off to do the flip stuff.
Oh, right.
Yeah. I won't be live when the next one comes through there.
Can we pass this to
Thursday or
the
work.
state to see if they have any objections?
Yeah, Thursday, fourth, that was 12. Yeah,
And it's a criminal trial division.
Okay. Sure, I didn't miss something. All right. No, I gotta be, I can be
Okay,
in the courthouse anyhow. No big deal.
all right, thank you.
Okay.
Yes, all right, thank you. You can just toss it since we've already done it. I think that was a duplicate then.
You got on Bob. Correct.
Okay.
Can you explain what should be? Have a policy? Do I
Yes.
give her the original, just send her the whole thing?
Yeah, just send her the whole
Okay.
thing. Oh, no problem.
Yeah, let's do that. Clearance for that.
Norma, these are for you.
Emily? Let's see, I think she ended up.
Yes.
Okay.
Is that what they just signed? You went over there. Attorney for Emily?
Carl. You're fine.
I'm trying to swear her in, but she's not answering yes or no. She wants to go over there.
It's a.
Oh, you wanna? Yeah.
All right, who are the parties on Terrell Goodry? And probation, this is an application. All right, and Deputy, if you could move Pettis down to that end. All right, court is calling 2024 CR 0964, State of Texas versus Terrell Guidry. Could I have parties announced for the record for the state? Defense,
Probation, yeah.
are you Mr. Guidry?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Guidry, did you file a document entitled Application for Community Supervision or Deferred Adjudication? Well, you're only eligible for deferred adjudication in this instance. Did you review that document with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am. That's the charge. Did you understand what you're
Oh,
charged with?
yeah, yes, ma'am.
All right, you need to stop whispering. You need to speak up. You understand?
Hello.
No, I mean, speak up the way you would speak with your friends. Right? In the same tone. All right, so did you review the true bill of indictment with your attorney and did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes.
Mr. Guidry, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up your rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, thank you, and sentence you up to 20 years in prison and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
Yes, he has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
In my opinion, he was, Your Honor.
Mr.
And he is
Guidry,
this time.
oh, thank you. Mr. Guidry, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No,
Are you satisfied with the way you've been?
no, ma'am.
Okay, I'm sorry. All right, you're gonna have to speak up. Open your mouth and speak up.
The microphone is.
I mean, he's just whispering.
Is it good?
No, it's not.
Oh.
And don't hold the mic like you're about to bust out in a rap, just,
Yeah, it's on.
all right.
Hello, hello.
So you're gonna have to speak up.
Speak a little like you.
Because I know people don't whisper when they're around their friends. All right. Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, state recommends deferred adjudication. They're taking in consideration the following county court cause number 706-965, 706-966, 695-664. There's to be restitution in the amount of $608.62. Is that to Derek Sims?
Yes.
And that's to be paid to Derek Sims, SIMMS. There's an affirmative finding of family violence, and there's to be no contact with Derek Sims. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition? Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
What does that mean?
All right, you'll need to speak to your attorney about that.
Oh.
You want to talk to him? Yes. All right, we're off the record.
Okay. I'm sorry, I didn't discuss that.
No, no.
I discussed the firearms. I didn't-
Okay.
Yeah, she's right next to me. Yeah, I'm standing right next to her.
Hey, Your Honor.
All right, we're back on,
I forgot to
We're
discuss
back
the
on the record.
firearms. That's what they always ask me about. Okay.
no problem. All right, we're back on the record. So did you understand that with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent? Did you understand?
Yes.
All right, did you understand that to be the entirety of your plea bargain agreement? Defense,
Yes, Your Honor.
state? Did you review the paragraph entitled waiver of appeal paragraph with your attorney? Did you understand it and did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there be any such motions?
No, Your Honor.
Outside the agreement, state is requesting that your community supervision be for a term of 5 years and there be a TAP evaluation. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
That's fine.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
Contest.
State any evidence.
Your Honor, state offers states exhibit all and all its taxes.
No objections, Your Honor.
All right, and state, have you had contact with the complainant?
We have.
All right, and they're aware of this agreement?
Yes.
All right, you may continue to confer. Yes. All right, did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
That's fine.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
That's fine.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
You may continue. Which prosecutor?
Cordero?
No, which prosecutor?
Neil Cordero.
Neil?
Yeah, Neil did these. He signed. I'm not. These are pre-amended. And Neil, who may call it?
Yeah, because he's missing, I'm missing the signature there. And then
I'm sure. Sorry. Yeah, I'll give it to him. Neil is in the felony.
Uh-huh. you know, I need the signature.
Okay. Sure. Neil, I was on.
Okay, what's that? No, for the mics. We'll see if you can hear me. Yeah. Bring that one over here.
All right, after reviewing states exhibits one and attachments, the court will find there sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Your
Do you have anything you wish to say on behalf of your client?
Honor. As the court can see, I have a client here. He's very young. He's read the documents. There have been some family issues between him and his mother that probably led up.
We're on the record. You may continue.
It's not to excuse what he did, just kind of explain his actions. He knows he did what's wrong. And I think he would be a good candidate. He doesn't any prior, except for other misdemeanors that I know of, Your Honor. He's also asked me to request support for some help on education and training for jobs, things like that. He's asking if there's any programs that they can provide that would help him with that.
All right, how old are you?
21.
All right, so I don't even understand how this all got to this point. You have somebody, Tiana. Is Tiana related to you?
My sister,
All right, so and how old is she?
20 or 19.
Okay, she's 19. So she posts on Facebook a picture of Roxanne and her ex-boyfriend because it was his birthday and he's passed. So what is her relationship or your relationship to Roxanne's ex-boyfriend?
Like my dad, basically.
All right, but he's not your dad. He's your stepfather or something?
He was basically, yeah, he was there, he raised me.
All right. So Roxanne gets upset because she's now moved on with another guy, right?
Mhm.
And she wants to know, why is Tiana posting pictures of her on Facebook with her ex-boyfriend, who's your stepfather, right? And instead of that being the end of it, you and Tiana decide to drive over to Roxanne's house, right?
Technically, yeah.
Well, I mean, not technically, either you did it or you didn't.
Yeah.
All right. So you go over there. Why are you keying Derek Sims' car?
He called me outside the car to come fight him, and I'm not finna fight him. But I mean, I'm finna get like, I don't know, a point across basically.
And what is your point with him that you want to get across? Why are you even going to that location?
I went because my sister called me crying. She had to go pick up her dog, and I went with her.
All right. But she's not really over there for her dog. That's just a side thing.
That's the main reason she went.
No, she went over there because she posted a photo.
Well, Your Honor, she did go pick up a dog.
No, I mean, ultimately, that's a side trip. Her main reason for going over there was she posted a photo of Roxanne with her ex-boyfriend who's passed,
Right,
your stepfather, and everybody's upset. Roxanne is upset. Stop posting photos of me with this ex-boyfriend because maybe her new man gets upset by that. And then that's when everybody comes over because it says Roxanne asked Tiana, why does she keep posting pictures like that? You don't think somebody else has feelings, referring to her husband, Derek Sims. And then your sister Tiana got mad and told you about the exchange. And then you started calling Roxanne several times. And when she finally answered the phone, you stated, where's your husband at? So this whole thing about the dog, that's just a side thing that people threw out there.
Well, she did say that his mother, who's is the one they did mention that she came over to pick her dog up, and there was a little dog when she left.
Oh, I know. But that's just a side thing. The main reason and what everybody got riled up over is because your sister decided to post on Facebook, which
That's
everybody says only old people use Facebook. I guess that's not true because these are 20 and 19-year-olds. Posted a photo of Roxanne with her ex-boyfriend, who is deceased and who is your stepfather and your sister's stepfather. So that's why everybody goes over there. And then all of a sudden you pull out a gun and they say the clip fell out. So why are you going over here? And it wasn't about the dog. So why did you feel the need to go over to somebody's house because you all are posting photos?
I'm not sure.
Well,
I'm not sure why I did that.
well, I mean, you can unfold your hands. You're not sure, but here you are in felony court, and this is going to be expensive for you. because fees are expensive. And this is deferred. Back in the day when you got a deferred, if somebody asked you, have you ever been convicted of a felony before? You could always say no. And that's all, that's where it would end on the job application. But now everybody knows about deferred. So on job applications now, it says, have you ever been placed on deferred? That's you. Do you have any children?
Speak up.
No, I don't.
How far did you go in school?
Thanks.
All right. So what are you planning on doing with the rest of your life?
That's what he talked about earlier, the program. I want to see if I can help me get into one to do CDL driving.
Okay. Well, I mean, that's easy to do. You just, well, they don't have yellow pages anymore, but you just go online.
I didn't
Yeah,
know.
but
He
there's a
just-
program for the city. I want to see if you can help me get into it. It's called Ready to Work.
Okay. All right. This is the court is going to do. The court is going to sentence you to 5 years deferred adjudication. Take in consideration County Court Cause number 706-965, 706-966, 695-664. There's to be restitution of $608.82 to Derek, Derek Sims, SIMMS, plus no contact with Derek Sims. There's to be 120 hours of community service restitution. That will be waived if you obtained a certificate from some sort of trade school. You say you want your CDL license. Once you obtain that, that will be waived. Or if you decide to go back to college. All right, this affirmative finding of family violence. Why are we saying this is an affirmative finding of family violence? I'm trying to see it. I don't see it. State,
That's,
because it appears that the people, like it, there's nothing here to say they live together.
no, they didn't live together. He didn't live with his, and his, the mother, if you see the videos, there's some animosity between the mother and the two. They have not lived together for a while.
No, I mean, I'm trying to figure out why is this designated as an affirmative finding of family violence, because they're not related. There's nothing in the police reports that say they ever lived together. You have a sister who's going to go pick up a dog. Did I miss something?
No, I mean, that's part of it. And there was other things. And it was a little, what, Yorkie, I think? I think it was like.
No, I mean, I'm just trying to get to the legal point of affirmative finding. The sister,
Sister and him, there'd have to be relation him and one. of the
no,
victims.
my understanding, well, let me ask you this. You're still under oath. And if anybody else knows the answers to this question, let me know. I'm not getting the impression from reading the police report that he's related to Roxanne. So they're not, is Roxanne your relative? Okay, you need to speak up. Can you say yes or no? Can you open your mouth and speak so that people can hear you?
She is.
All right, what is her relationship to you?
She's my mom.
Oh, so Roxanne is the mom.
That's,
Ah, that is not in here. I cannot believe you and your sister went to your mom's house with all of this foolishness because she's dating somebody else. Your sister's 19, you're 20. Hey, maybe you love the stepfather more than you love the mom, but guess what? Your mom has moved on. And either you're going to accept that or you're not going to accept it. It appears that she has chosen the man she is with. That's who she wants to be with. She don't want you all posting photos of her with her ex-boyfriend. But guess what? That's up to you. You want to post photos of her all over Facebook with her ex-boyfriend? Fine. But that doesn't snowball into you and your sister going over there and causing chaos. This is not a Disney movie where you're trying to get her back with, you know, your stepfather or anything or like that. It's over. She's not going to be with that. Maybe she's not every anniversary. She's not celebrating that. Maybe she's moved on. Maybe she never loved your stepfather. I don't know. But what I do know, according to this police report, she has moved on with Derek Sims. And you all need to accept that. And if you can't accept it, then don't go over there. You understand?
Yes, ma'am.
All right, now I see why it's an affirmative finding of family violence. That wasn't in the police report. So there's an affirmative finding of family violence. There's going to be regular reporting by Zoom or in person. There should be regular random UAs. Field visits. One time per month for 4 months. And is there destruction of the weapon or forfeit the weapon?
Yes, Judge, I'm sorry, but it's going on this.
All right, there's going to be a forfeit of the weapon. Anger management. Probation, is there anything else he needs? Thank you. Proof of employment. Within 35 days, there should be no employment as a home health care provider or with minors. Anything else? Is there anything else you need from the court to be successful? All right, I'm going to show you what's entitled trial court. Oh, and I'm sorry, there's an affirmative finding of a deadly weapon. Going to show you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. Sometimes we don't like the partners maybe that our parents may choose. But guess what? Sometimes your parents don't like the partners that you choose. Guess what? Everybody's living their own life. They're adults. People can choose whomever they want to be their partner. Your only choice you have to make is either you're going to accept it or not. If you're not going to accept it, then move on. You understand? Now, from here on out, everything that you do, you need to ask yourself, is this something that could potentially result in me going to prison up for 20 years? If the answer is yes, don't do it. If it's maybe, don't do it. In this court, to be successful on probation, communication is key. Talk to your probation officers if there's an issue. If you feel they're not addressing it, you can always come back to the court. Good luck.
Good job.
Okay. Who's here on Joe Anthony Thomas?
Here,
Oh, it's on the record. Yes. Court is calling 2023 CR 11355, State of Texas versus Joe Anthony Leopoldo.
yes, Judge.
Thomas, could I have parties announced for the record for the state?
Hank Wilkins to say, right?
Defense?
Adam LaHood for the defendant.
All right. And are you Mr. Thomas?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Thomas, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
We already are, except for waiving the habitual offender advancement.
We have no objections to that waiver, Your Honor.
Showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Okay. All right, let's go off the record. Can I have attorney's approach?
Yeah.
Give me this. All right. Mr. Thomas, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review this document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, I did.
You understand you're charged with felon in possession of a weapon. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am, I did.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 10 years in prison and up to $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes to both, Your Honor.
Mr. Thomas, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $500 fine. State recommends deferred adjudication. They will take in consideration 2024 CR 1106. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Judge.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am, I do.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the agreement. The state is requesting that your community supervision be for a term of 4 years. There be a TAP evaluation, 100 hours community service restitution, no contact with Christopher Michael Talamontes, Vincent Bernard Alanese, Joshua Patrick Helton, the Rings of Fire tattoo located at 110 Jefferson, San Antonio, Texas, 78205, and SATF. Did you understand? So those are recommendations from the state and the court does not have to follow those recommendations.
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Contest.
State any evidence.
Your Honor, I offer States Exhibit 1 and the attachments.
We have no objections, Your Honor.
All right, did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, I do.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
All right, anything you wish to say on behalf of your client?
Yes, Judge. So we're I think obviously we're not opposed to being granted deferred. It's what we asked for and applied for. What we are asking to do is take a look at whether or not SATF is an appropriate remedy for him. We were here on the MTR about a month and a half, 2 months ago. I lose track of time. And I believe at that time he was ordered to do a TAP evaluation, and that's where the SATF recommendation came from. However, Judge, I think if you, I hope there's a copy in the file. If you look at the evaluation report, he was honest about everything that happened. There was alcohol consumption that night, but he's been clean of hard drugs for a very long time. Add to the fact he's been in custody now, I think about 5.5, 6 months or so. We're hoping the court would see fit to either not order SATF, order outpatient, hold SATF in abeyance, just something to avoid an inpatient track, simply based on the fact, one, he's been in custody a long time. I don't know if SATF is necessarily the least restrictive means to get him any treatment that he may need. For that reason, Judge, we're asking to avoid sending him to SATF at all possible.
All right. Anything you wish to say?
Oh, no, no.
All right, this is what the court is going to do. Court is going to sentence you to a $500 fine. That'll be probated. Sentence you to 5 years deferred adjudication. Take in consideration 2024 CR 1106. And there was the second number.
Judge, the other case is not being TSC'd. I'm dismissing it for missing witness of the assault.
All right.
Yes, Judge.
All right, so I've signed the dismissal on that one, and that's cause number 2023 CR 11354.
Yes, sir.
And this will run concurrent with. Let's see.
Sorry, Judge, I forgot, but it is meant to be concurrent with this other case.
All right, and that will be concurrent with 2022 CR 3270. There's to be no contact with the following persons: Christopher, Michael Talamontes, Vincent, Bernard, Alaniz, Alaniz, Joshua Patrick Helton, Heltion, The Rings of Fire Tattoo at 110 Jefferson, San Antonio, Texas 78205. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. I'm sorry, not regular random UAs, the UA hotline. Probation, do you think SATF is where he should be?
I'm sorry, Michelle. I apologize. I didn't know.
Honor, if the court deems appropriate, we would recommend intensive outpatient treatment, monthly urinalysis, and sober support meetings as the lesser modality.
All right, then it's gonna be regular reporting by Zoom or in person, the UA hotline, intensive outpatient treatment with probation, and 90 sober meetings in 90 days. Proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. Field visits 1 time per month for 6 months. And then at probation's discretion. And gang evaluation. Do you have children?
Yes, ma'am.
How many?
One man,
Age?
7 years old.
200 hours of community service restitution. I'm going to order parenting classes. Once he completes that, the community service hours will be deemed satisfied, and there's to be no unsupervised contact with minors. Probation, is there anything else? Is there anything else you need from the court to be successful?
No, ma'am.
Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? Did you sign it and all and in the appropriate place?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. You understand?
Yes, ma'am, I do.
All right, we can go off the record. Here's the thing, I remember your case. I remember that video. You were on the side of the street at a tattoo shop, just as intoxicated as you could be. Obviously, you have a drug or alcohol problem. We're trying to solve that problem for you. If you do not want to potentially end up in prison for 10 years, you had better straighten up your life. You understand?
Yes, ma'am.
All right, good luck to you, okay?
Thank you, ma'am.
Yes,
May I,
yes.
on this other case that he's actually on probation for,
Mhm.
the conditions were amended for status. Can we re-amend or
Yes, we
make an
will.
amendment to that
Yes.
for
And
intensive outpatient treatment?
all right, and cause number 2022 CR 3270. The conditions will be altered and amended to include intensive outpatient treatment, the UA hotline, and 90 sober meetings in 90 days. Yes,
Can I ask a question?
sure.
What is the UA hotline?
Oh, probation will explain it to you.
Thank you.
You're welcome.
Thank you, Your Honor.
You're welcome.
Thank you, ma'am.
All right, you may be seated.
Thank you.
You're welcome. Yes. It is 2022 CR 3270. Mr. Baker, who do you have?
Mr. Bond, Your Honor?
Are you all ready on that?
Yes.
Okay. Court is calling 2024 CR 0982, State of Texas versus Jerry Banda. Could I have parties announced for the record for the state? Defense?
Eric Baker for Mr. Bond, who's present.
All right, and are you Mr. Banda?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Banda, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
So wait, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving one of the enhancement paragraphs, the last paragraph, proceeding on repeater, ag assault, deadly weapon.
All right, so the paragraph 2 in the enhancement is what you're waiving?
Yes, Your Honor.
Any objections?
No, Your Honor.
All right, Mr. Banda, showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with aggravated assault with a deadly weapon? That is normally that's a second degree felony. If the state is able to prove up the enhancement, then your range of punishment would be anywhere from 5 to 99 years or life in prison. Did you understand?
Yes, ma'am.
And up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do, Judge.
Mr. Banda, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, you'd agree that you previously been convicted of a felony of four. All right, who are those people at the door? Okay, thank you. All right, did you understand, part of your plea bargain agreement is you'd agree that you've been previously convicted of a felony before for terms of enhancement? Punishments be assessed at 5 years in the prison. There's an affirmative finding of deadly weapon. There are no applications, and there's to be restitution, if any, to Michael Huerta. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State? Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions? Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
Okay.
To paragraph 1 of the enhanced, I'm sorry, you're going on paragraph 2? Okay, no problem. To paragraph 1 and the enhancement, how do you plead? True or not true?
True.
State any evidence to support the defendant's plea.
Yes, sir.
No objection, Your Honor.
Right, you may continue to confer. Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements, police reports, and judgments? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. The court will find paragraph 1 of the enhancement paragraph true based upon your plea or true and based upon states exhibits 1 and attachments. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, just that I think this is a fair sentence in light of his past, in light of the facts of the case, and just ask the court to follow.
All right. Then the court will find you guilty as previously stated. Paragraph 1 enhancement true. 5 years in the prison. There's an affirmative finding of deadly weapon. There's to be restitution to Michael Huerta. There's to be no contact with Michael Huerta, and the court will give you credit for any time served. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. How old are you?
54.
All right, you're in the same shape I am. We're in the twilight of our life, unless we're expecting to live 60 more years, right? So you're gonna have to make a decision. Do you want to continue doing this back and forth, going to prison and living the rest of your life in prison, or do you want to get things together? The choice is yours, okay? All right, good luck to you. Thank you,
Yes.
counsel. All right, who is here on? Rolando Gomez. All right, court is calling 2024 CR 1562, State of Texas versus Rolando Gomez. Can I have parties announced for the record for the state?
Jason Garrett, Hancock.
Defense,
Roger Pettis, Your Honor.
are you Rolando Gomez?
Yes, Your Honor.
Counsel, had you received all the discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. All right, and there are no applications?
There's an application for probation.
Okay. All right, did you review a document with your attorney entitled Application for Community Supervision, and did you sign it?
Yes, Your Honor.
Going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, we are.
All right, so going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
All right, you're charged with burglary of a building with intent to commit theft. Normally, that's a state jail felony, and the range of punishment will be anywhere from 180 days up to 2 years in the state jail facility. But the state is proceeding on this with your habitual allegations. If they're able to prove that up, then this will be a second-degree felony. Range of punishment will be anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Gomez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Yes, Your Honor.
No, listen
No.
to me carefully.
Oh,
Has
okay.
anyone threatened you, forced you, or placed you in fear to get you to enter this
No,
plea?
Your Honor.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Going to show you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, you'd agree that you've been previously convicted of one or more felonies for enhancement. Punishments to be assessed at 4 years in the prison. The state will remain silent on your application. Did you understand that to be the plea?
Yes, Your Honor.
Defense,
It is, Your Honor.
state, showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? And did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
There has not, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
To paragraph 1 of the enhancement that's listed in the true bill of indictment, how do you plead to paragraph 1? True or not true?
True.
To paragraph 2 in the enhancement, how do you plead? True or not true?
True.
State any evidence.
No objections, Your Honor.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, court will find there is sufficient evidence to find you guilty. Court will find you guilty. The court will find the enhancements in paragraph 1 and paragraph 2 true based upon your plea of true and based upon states exhibits 1 and attachments. So with regards to this case, is everyone okay with the court receiving a criminal history and having a TAP evaluation done at the jail? Otherwise, it's probably going to be 8 weeks maybe before they have everything completed as far as the PSI report.
I think that would be fine, Your Honor.
All right. So Ms. Abrams, when will the TAP be done?
2 weeks.
Okay. So Norma, can we set this in? Let me look at the calendar. Can we set this the end of April, April 29th or 30th or something? All right, April 30th.
Yes, Your Honor.
All right, so on this one, I'll just need the TAP evaluation and state you'll provide a list of the criminal history.
Yes.
All right, Mr. Gomez, I'll make a decision on your application based upon the TAP evaluation, the criminal history, and any other evidence that's presented to me. Do you understand?
Yes, Your Honor.
All right, we'll see you back on April 30th.
Thank you.
You're welcome. All right, could I see Castillo? Could I see the parties on Castillo? Oh, Mr. Castillo, you can remain seated. Can you mute us, please? I'm next to your office and I'm wondering, why is it so hot? All right, everyone, when the court reporter comes back, we're going to take up Can 2. And then after Can 2, it will be Briette and Perales. No problem. All right, Can 2, if you'll come up. And Diana, on Can 2, it's 2 cases.
Your Honor, how are you not bald?
Hmm?
How are you not bald? I would be bald by.
Genetics, I don't know. Oh. But you know, I will tell you this, each case that you hear, it's just a different case.
Yes.
So. All right, court is calling 2024 CR 4260W and 2024 CR 4259W, State of Texas versus Renee Angel Cantu. Can I have parties announced for the record for the state? Defense?
Lloyd Guerrero Jr.
And are you Mr. Cantu?
Yes, ma'am.
Counsel, in each of these cause numbers, have you received all the discovery and did you review it with your client?
I have, Judge.
Everyone, please make sure you whisper. In each cause number, the court will find that the state is in compliance with discovery. Mr. Cantu, in each cause number, I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it?
I sure did. Yes, ma'am.
And each cause number, going to show you what's entitled waiver of indictment, reading of information, and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review those documents with your attorney? Did you understand them?
Sure did. Yes, ma'am.
And did you sign it?
Yes, ma'am.
Did you understand you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not to indict?
Yes, Your Honor.
Did you understand you have a right for your attorney to have 10 days to prepare for trial?
Yes, ma'am.
And did you understand you have a right, your attorney has a right for the passage of 2 days after the presentation of the information? Did you understand?
Yes, ma'am, Your Honor.
Did you understand by entering into a plea bargain agreement in each of those cause numbers, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights?
Yes, ma'am.
And each cause number, the court will find that defendant has knowingly and voluntarily waived indictment, reading of information, and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. And each cause number, I'm showing you what's entitled information. Do you need some help?
It's for you.
What?
Or is the notes after?
Oh, you want to say something?
Yes,
Okay,
ma'am. Sorry about that.
no problem. All right, did you review the information with your attorney?
Yes, ma'am. Sure did, Your Honor.
Okay. Counsel, do you waive the reading of the information?
We do.
State, are you proceeding on the information as presented in each cause number? All right, in each cause number, I'm showing you what's entitled court admonishments and defendants' waivers and affidavit of admonitions. Did you review those documents with your attorney? Did you understand it?
Yes, ma'am. I did, Your Honor.
And the cause number ending in 4260W, you're charged with possession of a controlled substance, penalty group 1 over 400 grams. Range of punishment for that offense is anywhere from 10 to 99 years or life in prison and up to $10,000 fine. And the cause number ending in 4259W, you're charged with manufacturing delivery of a controlled substance, penalty group 1, 200 grams to 400 grams. The range of punishment is 10 years to 99 years or life in prison and up to $10,000 fine. Did you understand?
Yes, ma'am, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand,
Yes, ma'am, Your Honor.
counsel? All right. Just one second.
Yes.
Did you understand in each of these cause numbers, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
I do understand, Your Honor.
Did you understand by entering this plea in each of these cause numbers, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Absolutely.
Do you believe he has a rational as well as a factual understanding of the charges against him?
No doubt in my mind.
Do you believe he's currently competent and was legally sane at the time of the offense?
Totally.
All right, Mr. Cantu, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am, Your Honor.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
100%.
Are you a U.S. citizen?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, I'm showing you what's entitled the plea bargain agreement. Did you review that with your attorney? Did you understand it?
Yes, ma'am, Your Honor.
Okay. According to the plea, punishment is to the court and it's an open plea. The state is going to oppose your applications. Each cause number will run concurrently with each other. Is that correct?
Yes.
And those cause numbers are listed in the plea bargain agreement as CM 105822 and CM 105821. Do those numbers correspond with the waiver numbers?
Yes, Judge.
Okay.
In each case, they match up.
All right, and then in each cause number, the state is taking in consideration CM 104043, NIMAC number 712122, and 712121. Did you understand that to be the plea?
Yes, ma'am, that's correct.
Defense, is that the plea?
It is, Judge.
State, is that the plea?
It is, Your Honor, but can you off the record for the approach?
Sure. Oh, just one second. Can you mute us, please? And defense, if you'll come around. All right. So off the record, the state's attorney has informed me that the intake attorney actually did the plea paperwork. Is that correct, state?
Yes, ma'am.
All right. So did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am, sure did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
Pardon?
Have there been any such motions?
No, no, Judge.
All right. Then in cause number 2024 CR 4259W, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
And then in cause number 2024 CR 4260W, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State, any evidence?
State offer states one, into evidence of states one and all attachments in both cause numbers,
And announce for the record.
and Neil Cordero for the state of Texas.
All right. Going to show you what's entitled waiver and consent to stipulation of testimony and stipulations in each cause number. Did you review those documents with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, I understand, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. And if you could mute us, please. Each cause number, the court will find there's sufficient evidence to find you guilty. And each cause number, the court will find you guilty. I need a sentencing date, TAP evaluation, and PSI.
I'm out of state that first week of June, Judge.
All right.
Do it sooner.
Hmm?
I can do it sooner or
The
later.
only problem is, this is the length of time we're given for them to have PSIs ready. So let me see.
11 for the third.
Fine.
All right, June 11th. All right. Then we'll come back on June 11th. Probation, this is a TAP evaluation and a PSI. And then the court will make its decision on your application based upon whatever evidence is presented to me and based upon the TAP and the PSI.
Thank you, Judge.
Okay.
Judge, may I put something else on the record briefly?
Yes.
It's an open felon in possession of a firearm case, cause number 2024 CR 1090 attributed to this defendant. That case is going to be dismissed as part of this plea bargain agreement, but it's not going to be taken into consideration.
Okay.
As the defendant is just not going to plead true to that. I just wanted to put that on the record that way, in case, I'm not here to handle the plea or, I just want to make sure that's on the record. That way it gets done.
All right, so it's not a part of the plea bargain agreement, correct?
It is a part of the plea bargain agreement. It's just not getting taken into consideration.
It's being dismissed outright, Judge.
It is being dismissed.
Another
outright.
defendant has been convicted and accepted responsibility for that.
And so it will be dismissed for once this plea is taken.
Is there a reason why it can't be dismissed now?
No reason at all.
I don't understand. If it's not being taken in consideration, then,
I'll go ahead and submit a dismissal for it now.
okay. All right, thank you.
Thank you.
Thank you, Your Honor.
All right, thank you.
Our next issue.
Oh, yeah.
Motion.
Remember, we were here this morning on his asking the court for reconsideration on this GPS.
Yes. May we hear that?
We can hear that, but what I can tell you is I've read the facts of this. You should probably still be on GPS. It's really for your benefit
Okay.
as well, because then people will know exactly what you're doing.
Yes, ma'am.
He has done, as this court probably has been informed,
Mhm.
a superlative job.
Yeah.
And I even have a letter today from probation for you to tell you how well he's doing.
All right, awesome. Just keep up the good work
Yes, ma'am.
and stay on tracking.
Yes,
That's
ma'am.
okay.
Thank you, Your Honor.
All right, you're welcome.
Take care.
All right, thank you.
Okay.
Sure, no problem.
Who's,
Yes.
oh, Ms. Free? Free? Okay.
Yes.
Next.
Yes, we'll take that up.
Thank you. Thank you. Emily?
No, I'm sorry, he needed to come back. Okay.
Or Judge, she went to the bathroom. Can we get Mr. Pinellas?
Sure.
Thank you.
Mr. Pinellas?
I'm excused. Thank you. Thank you, Your Honor.
You're welcome. Does he need to speak to probation?
Yes, ma'am.
Yes. Okay.
Yes.
Judge,
I give it to you.
may I approach- did Jesse Rivera contact you about his availability, or is that?
No, he has not.
Okay,
contacted
that's
me.
fine. He told me he was not available, he told me he was, and so we're just gonna.
Yeah, okay. All right, thanks. All right, could I see the parties on Perales? Court is calling 2024 CR 0208, State of Texas versus James Ryan Perales. Could I have parties announced for the record for the state? Defense?
Roy Barrera Jr.
And are you Mr. Perales?
Yes, Your Honor.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Judge, I have.
Court will find that the state is in compliance with discovery. Mr. Perales, I'm showing you what's entitled application for deferred adjudication, community supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, Your Honor.
Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Do, Judge.
State, are you proceeding on the indictment as presented?
Yes.
Showing you what's entitled Waiver and Consent to, Waiver, Courts Admonishments and Defendants Waivers and Admonitions and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
You're charged with the offense of evading arrest or detention with the vehicle. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Completely.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Totally.
Mr. Perales, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you that anything other than the plea?
No, Your Honor.
Satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, there's a $500 fine. State recommends deferred adjudication. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
It is, Judge.
State?
Yes, Judge.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the agreement, the state is recommending that your deferred adjudication be for a term of 2 years. There be a TAP evaluation and 120 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State offer states to the one and all attachments.
No objections?
All right, you may continue to confer. Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Yes, Your Honor.
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding you guilty as you apply for deferred adjudication. Are you proceeding with sentencing?
We're ready?
Yes.
Yes.
Anything you wish to say on behalf of your client?
Absolutely, Judge. That's one of the brightest, cleanest, well-groomed young man that I've had the pleasure of representing lately. And he has a very bright future, college and beyond. So this was a situation that just escaped his better judgment and he is taking full responsibility for what he's here for. And I have great hopes that he continues with his plans.
All right, so why are you doing something so foolish?
I wasn't thinking right, Your Honor. I don't believe I was thinking at all.
All right, so how old are you?
22, Your Honor.
Do you want to get a taste of prison life or jail life?
Not at all, Your Honor.
All right, so you're gonna have to start making better decisions. I don't know why today there's been a lot of evading cases that I've received. Don't know what's going on with people. So the way you were driving, you could have ended up killing somebody. Or you could have killed yourself. Then your parents crying, right? Or either you killed somebody else and then you're not here for an evading, you're here for something else that is far more serious than just an evading. You understand?
Yes, Your Honor.
So what are your plans for your future?
I'm in college currently, Your Honor. I want to become a nurse. I also want to go to volunteer in clubs as well as other community groups within my college. So I want to go and become a member of the community so that way I can apply for scholarships and whatnot.
Okay, so how far are you in college? What year?
I'm in my first semester that's so I started college whenever COVID started and that's online strictly.
Mhm.
So that didn't do too well for me. So I had 3 attempts, but this is the last attempt where I will go and succeed.
Okay. So what courses are you taking?
Right now I'm taking one class, which is EDUC, because I had failed the other classes due to COVID.
Okay. All right, the court is going to sentence you to a $500 fine that will be probated, 2 years deferred adjudication. And I'm assuming, I've learned I should not make assumptions. Please tell me, you don't have any children, do you?
No, ma'am.
Okay. No, not expecting.
No, ma'am.
Okay. I always ask that because you need to get yourself together before you start bringing another human onto the planet. You understand?
Yes, Your Honor, we agree.
All right, $500 fine probated, 2 years deferred adjudication, 120 hours of community service restitution. That will be waived if he completes his degree.
Thank you, Judge.
You're welcome.
Thank you, Judge.
You're welcome. I don't know if 2 years will give you enough time to complete your degree. So if he completes his degree, then it will be waived. And also if he is a full-time student. So for me, one class is not going to get it. When I was in college, over the summertime, I took 12 hours. And each semester I took 24 hours because I quickly learned that when you get to a certain point, when I was in school, once you get to 12 hours a semester, anything over 12 hours was free. And I was like, hey, nobody should have told me that. So I was doing 24 hours a semester. And then I figured I was in high school. We had 6 classes. And in college, all they're asking you is Monday, Wednesday, and Fridays, and Tuesdays and Thursdays. I was like, how hard could it be?
Exactly.
So for me, if you want credit and you haven't completed your degree, then you need to be in school full time. And I'll go easy on you, at least 9 hours. You understand? And then none of this W business. I learned about W's too when people said, oh, Stephanie, just withdraw. So if you start out at 12 hours and then you just slide in with a couple of W's, that will not count for me. You understand?
Yes, Your Honor.
All right, there's to be regular reporting by Zoom or in person. There'll be regular UAs. You can either do the regular UAs or you can do the patch. Your counsel will explain to you, patch costs more, but with the patch, they just put it on you and then you come back and let them take it off. There is to be defensive driving, proof of employment or full-time enrollment in school within 45 days. There's to be no employment with minors or as a home healthcare provider. If you go through your college and they want you to start doing an internship or something as a home healthcare provider, you can come back and ask the court. And I may allow it depending on how you've been doing on probation. You understand?
Yes, Your Honor.
Field visits. One time per month for 2 months. Probation, is there anything else? Is there anything else you need from the court to be successful?
Your Honor, I have one question.
Sure.
Whenever I'm applying for jobs, do I have to go in and say yes for whenever I was convicted of a felony?
Well, this is not a conviction. What I can tell you is back in the day, when I was 21, which was 2 years ago. Okay. Yeah, last year. There used to be a time where you would fill out a job application and the only thing they would ask you is, have you been convicted of a felony before? And you could say no, because this is deferred adjudication. It's not a conviction, right? But now they go a step further on some applications. They ask, have you ever been placed on deferred adjudication? So if they ask you that, you have to be honest. If they ask you if you've ever been convicted, the answer to that is no, because this is not a conviction. You understand?
Understood, Your Honor.
All right, is there anything else?
Thank you, Judge.
All right, thank you. Oh, could I see the state and Mr. Barrera, if you could come around, please? And state. And Mr. Castillo, I believe your attorney, oh, there he is. Come on up. Oh, I'm sorry, that wasn't it. Oh, thank you. And this is this one. And I think that's the one that was dismissed, correct?
Yes.
Oh, and then I have this. All right, so Mr. Castillo, you were scheduled for trial today, but 2 things. One, the jury had been here for a while, and I never like to have people do jury selection when the jury has been here for a while. I know the jurors will do their best, but sometimes people get very tired and maybe a little bit frustrated. And then the other thing, my understanding, this is a relative new case, and my understanding is that a new offer was tendered. Is that correct, counsel?
Yes, Your Honor.
And then also some added information was tendered to you. Is that correct?
We understood that the complainants are not to be found, at least up to this point.
Okay.
Although the state, I think, is still looking for one of them.
All right. So state with regards to complainants, nowhere to be found. I'm going to recall this then. And April 29th. Is that good for everybody?
I think that's fine, Judge, yes.
All right.
That's the week after Fiesta, correct?
Yes.
Okay, I'll be back. Okay.
All right. So we're going to do April 29th, Ms. Ferguson. And at that point, state either you have your witness or you don't. Okay. All right. So April 29th. All right. Is there anything else?
Judge, his GPS monitor,
Okay.
like the state, my client doesn't know these complainants, doesn't know where they are, hasn't had any contact with them. He's had at least a year on this device without violations or any reports to the court. He'd like to ask the court to remove it. He does have custody of a 6-year-old. And with the summer coming, he'd like to take him swimming to the water park, like to go to his school with shorts on and not having to explain this device on his leg.
And Judge, the state can give you a copy of the police report. I guess it's facts and circumstances that are making us hesitate to agree to that.
All right. So is he on tracking or is he on something else?
I think he's on track.
All right. You're okay with tracking without a time period?
Yes, sir.
All right.
I'm already on that tracking.
Tracking without a time period?
I believe so. Last time we were here, it was discussed.
It was in Judge Nava's court.
Oh. All right. So if you all want to, I can't make a decision on whether or not to remove him from GPS or not without seeing, police reports or anything of that nature.
Understood, Judge.
Otherwise, if he's not, if y'all are in agreement, I'll put him on track and everybody will know where he is.
Well, he's already doing that. Yes.
No, I mean, I thought it was tracking, they think it was tracking with a curfew. I don't know. That was Judge Nahara who made that ruling.
I was talking to you last time I was here and you were the one that gave me the permission to be off of the time. And
Off of the
also
tracking time?
off of the track, the time, yes, ma'am. My
Oh,
curfew was-
so it sounds like he's still under a curfew then.
No, ma'am. Unless I am.
He's just 100% tracking with no limitations and Pierce. That's what I'm trying
All
to
right,
say.
so if you guys, I'll hear it if you guys want to pull the police report and everything. Okay, all right, so Jess, let me do that. We'll
Have a
come back.
seat. Have a seat.
Emily Fried. Oh, sorry, I think just have a seat. Your attorney went to the back. Tuska Hamrick. And Miss Abrams. So we'll get a new date then. If you're saying on his case,
Well, so the PSIs were, a PSI and stopped with on the case that he's on consultation for. So if you want to give more information on these other two cases, you can do a like a PSI, but it won't. I don't know if you're requiring a full PSI.
no, since I already have that, then we won't need a full one.
Okay.
So if y'all want to talk to his attorney, maybe about a different date, then. Okay. All right. What is happening with this case?
Your Honor, we've conferred, I know the state has indicated they want to contact their witnesses before they give me an offer. I had not reviewed the file today because I thought the case was tomorrow. So
Okay.
I want to review the evidence. But I'd like to set it for the 18th of April. I have to be here on another case and that will give
Okay.
us enough time.
All right, Ms. Ferguson, can you put this on April 18th?
Yes, ma'am.
All right, we'll bring you back on April 18th, okay?
Yes, ma'am.
All right, is there anything else?
Definitely.
All right, we'll see you then. All right, is there anyone else who are these two gentlemen?
Judge, I have Mr. Courtney.
All right, Nicholas Courtney.
The other one's Michael Stafford.
All right, could I see the file on Michael Stafford too?
Jesse Rivera's on this.
Okay,
That's the
Nick,
one that we have to pay for himself, for him.
okay. All right, Nicholas Courtney. All right, what happened to you?
Hey, I hit myself.
Okay. All right, what's going on?
Judge, there seems to be a question whether Mr. Courtney has any pending cases out of Caldwell County. And I'd like to ask the court for a couple of more weeks maybe to find out whether there are anything, cases pending or probation or anything out of Caldwell.
Yes, ma'am. So we got a TCIC and TIC criminal history, and I can see that, so the new number ones alleged in the MTR are cases out of Kerr County and Caldwell County. And it looks like from the criminal history that the Kerr County case has been disposed of, but the Caldwell County case looks, from the TCIC, it's from the criminal history, it looks like it's still pending. So we would like to ask for some more time because that'll affect the recommendation.
All right, so can't y'all just call the public defender's office?
That's what I plan on doing, either sheriff's office, public
I mean,
defender.
can we not pick up the phone and call them now and find out?
Well,
I mean, I'll give you all the numbers. I just Googled. Do y'all want to call and find out? It appears that things are not going well for him at the jail.
I can attempt calling him, Judge.
Okay,
If you have the numbers, that'd be great.
okay, sure.
Feels like Mr. Benevolent here.
That's the DA's office, and then I'm gonna Google the number for the public defender's office, just one moment.
We were here till almost 9 last night. He said we were here till almost 9. We were very out. Maybe we would probably not 7. Just because I was busy.
All right, oh, let me do this.
Judge, really quickly before we take the plea, I did take a look at this case. Initially, it's gonna be a plea offer for deferred. I did inform Mr. Rivera that after looking at the case a little more, I think PTE might be appropriate.
Okay. All right, so are you all in agreement with PTD?
We are.
All right, Ms. Ferguson, on Emily Friet, I need a new date for PTD.
On May 2nd.
I'm out of state, the first week in May.
May.
Perfect.
All right.
Will I get an email on that effect?
I'll
or-
give you a reset right now.
Okay, thank you.
All right, we'll see you back May 9th.
Who's gonna give you?
Thank you, Judge.
You're welcome. So do we only have 3 cases left?
Give me 1 second, Judge, and I can grab that.
Yes. Yes. Which is done.
It's like coming back from June. I mean, I think she has all the information she needs. Judge, do you want anything else on campus?
No. Just if y'all can do sort of like an amended, because we already have that. So there's really nothing else that's needed. April 18th.
I mean, do you want our people to talk to him about anything?
I mean, if they can just reach out to him and he can tell them what he's been doing. But as far as needing more information, since that PSI has been previously done, we probably won't need more information.
Because I can get a status report from his probation officer for.
Okay, awesome. Then let's do that. So April 18th is fine.
Are you available April 18th? April 18th or Renee? April 18th. You can bring it back on the 18th. Yes, we'll just change it. Just not. April 18th.
And Norma, I need the VR reports on Jennifer Rodriguez, Ernest Mora.
Oh, thank you.
Emily, it's a lot of things that this. She's good to go, right? Yes. You can go now.
At least for and it's probably. You know,
We've been waiting for
Norma, can you check to see if Ernest Mora is currently in custody? Yes, his SID number is 729-776.
I don't know if you want me to do it on the record, but I did.
Oh, yeah, we'll do it on the record, but let me just read it.
No, ma'am.
Okay. All right, I'm ready on Castillo. Court is calling 2023 CR 10870, State of Texas versus Matthew Castillo. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense,
Raymond Martinez.
are you Mr. Castillo?
Yes, ma'am.
All right, the defense has previously filed motions to remove the GPS. And an order was entered by me on February 2024 for him to be placed on GPS tracking only and the fees waived. So we're now hearing the defense is requesting that the GPS be removed. Is that correct?
Yes, Your Honor.
All right. Defense, any evidence to present?
Judge, just we asked the court to take judicial notice of the court's file, which would indicate how long he's been on this device and whether or not any violations have been reported to the court.
All right. And state, any evidence?
Yes, Your Honor. The state tendered what we can mark as State's Exhibit 1. We presented it to Mr. Martinez for examination. I believe there was no objection, but it's the police report. It's the prosecution guide in this case.
All right. Any objections to
Not object, Judge, if that's part of their file, but I think if you read it closely, it's very clear that there's aspects of it that are not included, like video of my client talking to the officers and things like that. But that's part of it, yes.
All right, so the court will note that it's not the entire prosecution guide. Is that correct, defense?
Yes.
All right, so any objections to State's Exhibits 1
No, Your Honor.
for purposes of this hearing only?
No, Your Honor.
All right, then the court will accept into evidence State's Exhibit 1. Court has reviewed State's Exhibit number 1. Any other evidence besides State's Exhibit number 1?
No, Your Honor.
All right, the court will hear any argument.
Your Honor, the reasonable, actually, I think since this is defense's motion, I think the first argument.
So Judge, one of the things that you don't see in the state's exhibit, the officer clearly suggests that he has a conversation with my client at the scene of where he's getting arrested, and he asks questions of my client. He suggests in there that my client doesn't have an answer for some, what he thinks are relevant questions. But what's left out of that, and if you were able to watch the video, it would show that my client asked the officer, well, if I explain to you what happened, am I still gonna get arrested? And the officer tells him, doesn't matter what you tell me, I'm gonna arrest you. So then he doesn't answer any more questions. So in that context, it's somewhat misleading. What you do see in there is there's dispute about, there's a dispute on the roadway between two cars. There's two persons, two men in the other vehicle. My client is by himself. My client suggests that they approached his car, banged on his window, startled him, and then there was some back and forth. There's disputes about, is he following them or are they following him? Both appear, from what we can discern from our conversations in the 911, which is not in evidence. They're both concerned about whether or not the other car is going to follow them to their homes, because apparently they both live in the general area. So they kind of both stay on the roadway until my client's pulled over and arrested. There is an allegation that he pointed a weapon. I don't think there's any dispute that he's going to suggest that he felt in danger by them following him in their car. And as I said, if you look at his prior history, you look at his performance on pre-trial, I don't think he poses a danger to anybody, Judge, under the circumstances. I think he knows that he needs to be more careful about if people cut him off, just let him cut you off. If people are driving in an aggressive fashion around you, try to ignore them.
And let me ask you this. So how long has he been on GPS?
Since he made bond, right?
Oh, you want to raise your right hand? Do you solemnly swear and affirm the testimony you give will be the truth, and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Matthew Castillo.
All right, how long have you been on bond?
I believe I've been on bond since the day I got out, which was June 2nd. or 3rd.
Okay, June 2nd.
I was on house arrest for a month and a half, maybe. And then I was put on GPS tracking with a curfew from 7:30 to 10.
All right, and so you bonded out June 2nd. Is that June 2nd of 2023?
I believe so, yes, ma'am.
All right, and so have you been on GPS since June of 2023?
Since then, yes, ma'am.
All right. State, any other evidence or argument?
The only argument, Judge, is that from the state's perspective, this is a random road rage incident that occurred. There was no real reason as to why the defendant should have been following these people. I believe that in the police report, they indicate that they did call 911 because he was in his car flashing a gun at them, pointing a gun at them. And that's what kind of caused this all to happen. What the state's concerned about is that these are people that weren't aware of each other. They had no relationship, and this is how the defendant acted. So that was why the state's always asked for some type of GPS monitoring.
Okay, so, and both parties can help me understand. I've read the police report. I don't take any of it as true. I'm just reading it to try to make a decision on your bond conditions. I'm trying to figure out how being on GPS would in any way guarantee that there's not going to be a road rage. I'm trying to figure out what's the point of the GPS in this case.
Again, it could potentially show us if there's some type of gun store, if there's some indication there where another firearm's been purchased. That would be one of the state's concerns, but that's just one thing that just came to mind.
Okay. And are you employed?
Yes, ma'am.
What do you do?
I'm a cook at Albino at the Vineyard.
Okay. I mean, he's been on GPS since 2023. June of 2023. Have there been any violations while he's been on GPS?
As far as the state's aware, no.
Not that we believe, Judge, no.
All right. Have you had any violations on GPS?
I'm in. I mean, my charger went off, or the thing went off that it wasn't charged fully. That's about it.
All right. I don't understand why he should remain on GPS.
Again, Judge, I understand it just due to the nature of the events. We
Okay.
have to oppose.
And the reason why I'm saying this is because I could see, for example, if there is GPS because there's a complainant and somebody knows where this complainant lives and you don't want them going to a specific location. With regards to him, is there any specific location he's not allowed to go to while on GPS? Right, so then that's not an issue. Is he allowed to drive while he's on GPS?
Yes.
Have you been driving on GPS? Usually those are the things that I see. And I understand what you're saying, State, that it's just the nature of the offense. But usually when someone's placed on GPS, you know, with family violence cases, for example, we're trying to make sure that this person is not going to the complainant's house or anywhere in that vicinity. And here we don't even have a vicinity location because nobody knows where the people are. I'm going to grant the defense's motion for removal of GPS.
Thank you, ma'am. I
All right.
appreciate it greatly.
All right, and we'll be back on April 29th. And if there is some issue that develops, then we'll see where we are at that time. I just don't see the purpose of GPS if he's being allowed to go wherever, and we just want to see where he is. Okay. All right, so there'll be removal of GPS, and then we'll be back on April 29th.
Thanks, Judge.
All right, thank you.
Thank you.
All right, Stacker. Diana, here's this. Okay, we're here on a motion to revoke.
Yes, Your
Are
Honor.
y'all ready to proceed on the motion to revoke?
The state's ready, Judge.
We're ready, Your Honor.
All right, could I have the file stamp for motion to revoke, please? All right, court is calling 2000, thank you, 22 CR 10230, State of Texas versus Michael Stacker. Could I have parties announced for the record for the state defense?
Jesse Rivera, Judge, on behalf of Mr. Stacker, we're ready to proceed.
Are you Michael Stacker?
Yes, Your Honor.
Going to show you what's entitled motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
All right, are you the same Michael Stacker who was placed on deferred adjudication in 2022 CR 10230 for the offense of injury to a disabled person bodily injury on August 17, 2023 for a period of 5 years? Is that you?
Yes, Your Honor.
State?
State's proceeding in violation of condition number 2 that on or about the 19th day of October 2023 in Bexar County, Texas, the defendant Michael Stacker did then and there illegally use a controlled substance, mainly methamphetamine, in violation of condition number 2.
How do you plead to that? True or not true?
True, Your Honor.
The state's going to waive their remaining allegations. Your Honor.
Any objection?
There is no objection.
Did you understand by pleading true to violation of condition number 2, the court could find it true? Grant the motion, find you guilty, sentence you up to 10 years in prison and up to $10,000 fine.
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, Your Honor.
Court will find violation of condition number 2 true. Is there a proposed agreement?
There's a proposed agreement. The proposed agreement is that, or we're asking that the court find that he did in fact violate condition number 2, that you find that he is, adjudicate him guilty, revoke his deferred adjudication, alter and amend his probation to include safety and zero tolerance with regards to his other conditions.
All right, so I'll need if I follow this agreement, I'll need a trial court certification.
That's what I thought, Your Honor.
All right, so here's my question. Does he have open cases pending?
No, Your Honor.
They're all closed?
He has one, but I believe they're gonna dismiss it.
Correct, Judge, if you,
The burglary, that's here in,
it's here in Bear County, Judge.
okay. All right, you wanna grab, and that's being dismissed due to a missing witness? Kristen?
Thank
Oh,
you.
that's okay. It's rare that we get you here.
It's been a long day.
Yeah.
I'm glad to be here.
Oh, it's good seeing you. How's everything going? Oh, are we out of trial court certifications? Oh, do we have another trial court certification? We're out of so many things here. All right, while your attorney's filling that out, can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Michael Stacker.
All right, how often are you using meth?
I was using it probably every 2 weeks, ma'am.
All right, and have you been employed or no?
Yes, ma'am.
So why are you using knowing that I could send you up to 10 years in prison? What's going on in your life?
I just made a mistake. Started. a
No,
business.
no,
I
not
started a
mistakes.
business.
Not mistakes. You're making choices.
It's not gonna happen anymore. My choices led to my consequences. I tried to start a business, was going through a separation, and just went down that rabbit hole.
All right, separation with whom?
Just with my mother, the mother of my child,
All right. So how long have you been in a relationship with her?
10 years.
Okay, you want to have him fill that out?
Yes, just keep your secret.
All right, and with regards to this case, you're all asking that I find him guilty. What are you all asking that his underlying be?
5 years, Judge.
All right, is there going to be any objection to you to the underlying being 5 years?
No, Your Honor, again, he would definitely benefit from SATF or safety, whichever one he can get to first. I believe he's in pretty serious need of the rehab.
All right, and the length of probation, what are you all suggesting?
The length of
Yes.
5 years.
5 over 5 would be fine, Judge.
All right, are you in agreement with the outcome of this case as stated by the state and the defense, Mr. Stacker?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right, this is what the court is going to do. The court is finding violation of condition number two true. Court will find you guilty. The court will sentence you to 5 years in the prison, suspended and probated for 5 years. There's to be 120 hours of community service restitution. How old is your child?
She's 5.
Court is going to order parenting classes. Once he completes parenting classes, the court will deem the community service hours satisfied. Probation, does he need a new TAP evaluation? All right, the court is going to order a TAP evaluation in custody. There's going to be a felony drug court referral in custody. Proof of employment within 45 days of release. There's to be no there's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. Regular reporting by Zoom or in person. The UA hotline until further notice. Anger management classes.
Can the state make a request?
Yes, just give me one moment. All right, there's to be no contact with John Caras, Caras, or Michael Benford, Benford. And you said you had a request.
Thank you, Judge. I don't know if the court's willing to make as a condition of the bond that no harm or injury is contact or with the complainant on the vote cabinet is the mother of this child. The child was also present.
What's her name?
Mr.
Freedom, what's my name?
Right, WRIGHT.
And it's Freedom.
Yes, ma'am.
There's to be no contact with Freedom Right. If she wants to have contact with you, then she'll need to come in the court. You understand?
Understand.
And so there's not to be any cards, letters, Happy Mother's Day or anything of that nature with her. No contact whatsoever. You understand?
Yes, ma'am.
And just clarification, so we're on the same page, you indicated no contact with any minor children. Does that include?
No unsupervised contact with minors. So if you have visitation with your child, someone else needs to be present.
Understand.
And that needs to be somebody that's approved through probation.
Okay, so we'll let my probation officer know.
Yes. And is Child Protective Services involved in this at all?
Not that I'm aware, Judge.
No, Your Honor.
All right, so we'll do CPS compliance if applicable. Probation, is there anything else? All right, and field visits, one time per month for 3 months, and then at probation's discretion. And if he's not accepted into felony drug court, then follow the recommendations of TAP. All right, is there anything else you need from the court to be successful?
No, ma'am.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review this document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is an agreement that you've reached with the state and also because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
No.
All right, we can go off the record. In this court, to be successful on probation, you got to be in contact with people. Communication is key. If you have an issue, you need to let your probation officer know. If you feel as though they're not addressing it, you can always come back to the court. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome. Thank you. Yes,
Now
thank you. Good seeing you. All right. Hey, it's good seeing you.
I do have some cool stuff I wanted to.
Okay,
I
awesome.
wouldn't say cool, it's just historic.
All right. You know what? If you leave Norma, your cell number, there's something I want to send you about history too.
Oh, yes, ma'am. Of course.
Okay. All right. Thank you.
Because I accumulate all those things because I find it very interesting that, there's a majority of people in the state that are trying to take away the historical record of this country and this state in particular. And we should know it. This whole thing about it's gonna make somebody feel bad or whatever. Hey, the truth is the truth.
Yeah.
There's no reason to hide it, you know?
Mhm.
Because what if they do find out when they get older and be like, oh my God, is this?
Yes. But yeah, leave your cell number and I'll send it to you.
Yes, ma'am.
All right, Nicholas, Courtney, were you able to contact Caldwell County?
Excuse me, Judge.
He was, Your Honor, but we don't believe there's anything pending, in other counties, Judge, so, we can proceed with the MCR at this time.
All right. All right, court is calling 2022 CR 1615, State of Texas versus Nicholas Dean Courtney. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense,
Both analysis for defense.
are you Mr. Courtney?
Yes, ma'am.
Showing you what's entitled motion to enter adjudication of guilt and revoke community supervision and first amended motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Nicholas Dean Courtney who was placed on deferred adjudication in 2022 CR 1615 for the offense of assault bodily injury security officer on April 20th, 2022 for a term of 3 years? Is that you?
Yes, ma'am.
All right, state.
But this is on the first amended motion, Joe. Violated condition number 5 in Bear County, Texas. The defendant, Nicholas Dean Courtney, did then and there
Please.
failed to report to the supervision officer as directed for the months of July and August 2023 in violation of condition number 5.
How do you plead to that? True or not true?
True.
Your Honor, we waive the other violations alleged in the motion.
Any objections to the waivers?
No objections, Your Honor.
And Your Honor, the proposed.
Just one second.
Yes, ma'am.
All right, Mr. Courtney, did you understand by pleading true to violation of condition number 5, court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court will find violation of condition number 5 true. Is there a proposed agreement?
There is, Your Honor. We're asking that you deny the motion, continue the defendant on deferred adjudication. We're asking that you follow probation's recommendation, which is state ISF cognitive treatment, followed by ISP supervision. And we're asking that he remain in the Bear County Jail until his treatment bed becomes available at ISF, Your Honor.
All right. Are you asking the court to follow this agreement?
I am, Your Honor.
All right, probation. Is this what is being recommended? All right, Mr. Courtney, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Nicholas Courtney.
All right, Mr. Courtney, where have you been?
I've been, I guess, July, August, when I missed my probation. I went to Hayes County, where I was attempting to visit my grandmother. Who was ailing, and she was on hospice. I got picked up there in Hayes County and went to Caldwell. And from, I have a charge from back prior to the COVID episode. And then I finished that one up and came up here to Kerrville where I had a couple tickets. And now I'm here.
All right, so if you had to go see your relative, why didn't you just call probation and ask?
I had no way of making communication with anybody.
Well, here's the thing. You left Bear County to go somewhere else, didn't you?
Yes, ma'am.
So why you could not have left wherever you were to take a bus ride to probation? Probation does actually have a physical office.
Yes, ma'am. I had been there. I had lost my bus pass. I had lost all my property.
So again,
street.
here's the thing. You know where probation office is. Are you telling the court you didn't know where probation's office was?
I know the street, but without a way to communicate or use the internet to find the bus path or any of that stuff out there on Palo Alto, I had a lot of trouble finding it. Yes,
Oh,
ma'am.
do you know where a library is?
I know where the library. I found it.
Yep, you could have went to the library. The library has computers there that you're allowed to use for free.
Yeah, man.
So why didn't you do that?
I was not considering the library as an option. I did not think about the library. My mother being sick, I just went sort of crazy and I lost all my property and freaked out.
So he hasn't been seen since August of 2023. So we've almost not seen him for an entire year. And they said that he's already completed the DDRF program. So is there mental health issues here? Probation? Because it says on the court summary that he's the mentally impaired caseload.
He completed, did complete DDRF successfully. Here. It appears that the diagnosis that was reported was schizoaffective.
Mm-hmm.
That was based on a that was done in June of 2022. And it does appear that it's mental health needs. And I believe he's in a specialized unit or so forth with the jail at this current time.
All right. And then, so what I see in this from the stipulated evidence was that this entire incident occurred at a state hospital sort of facility.
That's the lunches.
Yes. All right. So, Mr. Courtney, here are your choices. And sometimes I can give people choices, sometimes I cannot give them choices. I can continue you. If I continue you, I don't know if ISF is appropriate, but it's what probation is asking for. Or either I can revoke you and I'll sentence you to 2 years. Which do you prefer?
Take
And
the
wh-
revoke, no.
Hmm?
The revoke.
Okay. Do you need to discuss that with your attorney or no?
Maybe just with y'all, if I'm like considered for back time and stuff like that.
Oh, you get credit for the time that you've been in custody.
Yes. All right, thank you. Yeah.
Do you want to talk with him for a little bit?
Yes, just
Yeah.
briefly. Yes.
And more information that I didn't have before. So I don't think it would be appropriate for me to sentence you to 2 years based upon how you classified at the jail. I think, and I could be wrong, I don't have a crystal ball, but there's some major, major concerns about your mental health. And what I've just been given more information that I didn't have before about your mental health and how you're classified at the Bexar County Jail. So I think it's probably best that I not revoke you and sentence you to 2 years, because I think you would be, based upon what I'm being told by all parties involved, that you may be a danger to yourself and also to others, okay?
Ever since my mother's passed, honestly, I've been going through a lot.
Okay.
And these are self-inflicted. I don't know how to, it's weird that somebody would just actually beat themselves and
Mhm.
something, it's like buried inside of me and I can't seem to figure out quite what it is. I think, I don't know how to explain it. It's like something I can't see or figure. And once she left, that's just been like talking and voices, screaming. scratching at myself and.
All right. So here's the thing. Does he need an evaluation?
Sounds like that wouldn't be bad.
I believe we can do that, Judge. I think we should do that.
All right. So if there's no objection, I'm going to allow the withdrawal of the defendant's plea of true to violation of condition number 5. Norma, on this case, there needs to be a competency evaluation ordered. So a competency evaluation will be ordered. He's to remain in custody until the completion of the competency evaluation. And Norma, once that's completed, Mr. Courtney, we'll have you brought back. Any objections to the court proceeding this way, defense?
No objections from defense, Judge.
Defense? I'm sorry, state.
No objection, Your Honor.
All right, so the plea of true to number 5 is withdrawn. And we'll do a competency evaluation. And Norma, let's reset this. Reset it for May 20th, maybe just to see where we are. So, Mr. Courtney, we're going to bring you back on May 20th. It may be sooner than that. Let Judge Carruthers Court know that there doesn't need to be an informal inquiry that I'm requesting a competency evaluation be done. All right, so that's the way we will proceed. And Deputy, thank you for letting me know that. Thank you. All right, is there anything else? All right, thank you.
Maybe excuse.
Yes. And Norma, I think that's the last case we have on the docket. Okay. And I don't think we have another case. We don't have anything set for tomorrow, do we? Oh, yes. Okay, so I'll be here tomorrow.
Yes, ma'am, with Mr. Roundtree.
And what time is that?
No. Because if you were gonna start trial, you told me you need to be here exactly at 9.
Okay. And how long are y'all expecting that motion to suppress to last?
It should be pretty quick, Judge. It's one officer witness, and then there's his body cam and his dash cam. And I think I want you to look at the dash cam. I think Mr. Roundtree wants you to look at the dash cam, or
Okay.
and so it should be pretty quick, Judge. Half an
Okay,
hour,
awesome.
maybe